I wish first to acknowledge the Ngunnawal people who are the traditional custodians of this land on which we meet tonight, and I pay respect to elders of the Ngunnawal nation, both past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples who may be in attendance tonight or who may be watching online. I invite our online audience to submit questions, and we shall address a selection of these during the Q&A session. If you are watching online, can you log questions at any time up until the beginning of the Q&A session? You can enter your questions as comments on the Amnesty Facebook page or on Twitter using the hashtag AskGillian. If you are watching online, Ask Gillian. Human rights in Australia and globally. David Mann delivered the first address, A Fair Go for Refugees, in Wagga Wagga on the 27th of March, in conjunction with the national launch of Amnesty's campaign for community sponsorship of refugees, My New Neighbour. Professor Gareth Evans AC will deliver the third address, The Responsibility to Protect Against Genocide and Crimes Against Humanity, at the ANU Copeland Theatre on the 23rd of May. Some of you may recall, by the way, that Gareth championed a Bill of Rights for Australia as then Attorney-General in 1984. So why tonight are we discussing an Australian Bill of Rights? Yes, this is the 70th anniversary year of the Universal Declaration, and Australia remains the only common law country to be holding out against expressing its international obligations in a consolidated charter. And yes, next year will be the 10th anniversary of the Brennan Report, the National Human Rights Consultation Report of 2009, which recommended adoption of a Federal Human Rights Act on the basis of both overwhelming public support and the need to address serious deficiencies in the protection of rights in Australia. And yes, Philip Ruddock's review of religious freedom begs the question, how can we address the balance of rights in the absence of a unifying statement of rights? Important as these reasons are, there is also the foreboding sense that as a nation we have lost our moral compass. And there are real lives at stake here. The lives of our indigenous Australians, the lives of thousands of children, women and men who have fled terror and persecution only to face the insanity, the neglect, the purposeful destruction of human dignity wrought by our immigration policies. The lives of Australians amongst us caught in the shackles of executive power beyond account, or caught in the most ordinary of circumstances where age, mental illness or incapacity leaves them vulnerable to abuse. A Bill of Rights would hold a legal mirror to what we as a nation hold decent. And it is time that what we hold as decent be tested, declared and legislated. It is time to get an Australian Bill of Rights back on the table, and we are indebted to Gillian for doing so tonight. I will ask Claire Mullinson to introduce Gillian. Claire is National Director of Amnesty International Australia, a position she has held since 2007. Claire's daily remit is to lead the 500,000 Australians who are involved with Amnesty in defending the rights to safe and dignified living that are abused daily in the world at large and here in our midst in Australia. Please join me in welcoming Claire.
Thank you, Peter. I also want to acknowledge the traditional owners on the land on which we meet tonight, the Ngunnawal people, and pay my respects to elders past, present and emerging. This is, was and always will be Aboriginal land. I'd also like to thank Peter and everybody who's been involved in making tonight's event happen. Peter is one of our volunteers at Amnesty, and you'll have met some of our other amazing volunteers. Many of them are dressed in yellow when you came in tonight. And as Peter's highlighted, Amnesty is a movement of amazing volunteers taking action to ensure that everybody's human rights are protected and defended. I also want to give a huge thanks to Professor Kim Rubenstein of ANU College of Law. Not only has Kim agreed to be on tonight's panel, but she and ANU have given fantastic support for this year's Amnesty Speaker Series, and I hope she'll continue that next year. So thank you, Kim. Now, before I formally introduce our very special guest, I'd like to take you back to 2009. Now, I can see from the audience that for some of us, that's quite easy to remember, 2009, but for others, it might not be that easy to remember because you might have been quite young. But 2009 was a year of hope. It was the year Barack Obama was sworn in as the first African-American US president. The International Criminal Court started its first ever trial, which would lead to the conviction and jailing of Thomas Lubanga for the use of child soldiers. Iceland elected the first ever openly lesbian head of government. And here in Australia, we hope that 2009 would bring about an Australian Bill of Rights or a Human Rights Act. During 2009, the National Human Rights Consultation process generated an unparalleled 34,000 submissions. Never has that happened before or since. And it was clear from those submissions and from the consultation that Australians believe passionately in a fair go and wanted to ensure that no one falls beneath the cracks. As a result of the consultation, the committee recommended the adoption of a federal Human Rights Act. Now, sadly, as we know, the then Rudd government ignored that recommendation, and Australia is still the only Western democracy without a Human Rights Act or a charter. And since that missed opportunity, Australia's human rights record has been extraordinarily inconsistent. The Land of the Fair Go created history last year by finally legislating for marriage equality. A terrible process, but a great outcome. But we are the nation where people fleeing terror, war, and persecution have been condemned to indefinite offshore detention. We're also the nation that has made a pledge to end the death penalty across the world. But we still watch the children, women and men on Nauru and Manus endure torture. They continue to self-harm and endure attacks without protection, without justice, all in the name of border security. Australia is the nation that played a key role in getting the global arms trade treaty over the line. Many of you here might have taken action to help that happen. But we continue to fund the Myanmar military despite their roles in crimes against humanity and ethnic cleansing of the Rohingya. As a nation, we have made significant voluntary commitments to upholding human rights both here in Australia and abroad by joining the UN Human Rights Council. But we incarcerate children as young as 10, and indigenous kids are 25 times more likely to be locked up as non-indigenous kids. Since 2001, our government has introduced 67 laws that threaten the human rights of all Australians. 67. These new laws have unprecedented deterrents on whistleblowers and the media. And new legislation is currently proposed that, if enacted, will tie charities up in red tape and silence them. This is similar legislation that has been used to silence and intimidate civil society and brave human rights defenders in countries such as Hungary and Russia. This is a slippery, slippery slope. And it's clear that the need for an Australian Human Rights Act is needed now more than ever. So given this context, we have the ideal person here tonight to speak on the subject of an Australian Bill of Rights. Professor Gillian Triggs is currently a Vice-Chancellor's Fellow at the University of Melbourne. Gillian has had a long and distinguished career, including Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney. She's been Director of the British Institute of International and Comparative Law and a consultant on international law to King, Wood and Mallinsons. No relation. Gillian was President of the Australian Human Rights Commission from 2012 to 2017. and Amnesty and I had the great pleasure of working with Gillian during this time. It was during her presidency that Gillian saw firsthand the extent and gravity of human rights abuses here in Australia. And it was as president that Gillian came under attack and a campaign to remove her from office. Throughout these attacks, Gillian retained not only her dignity, but her focus on championing the defenceless and the vulnerable. Please give a warm Canberra welcome in welcoming Gillian Triggs to speak this evening on an Australian Bill of Rights. Thank you very much.
Thank you very much. It's absolutely wonderful to be here and to see so many of you here on what, for me at least, is a cold night, but to see so many faces, young and not so young, interested in this question that's been off the political agenda in one way or another for a very long time. Can I too acknowledge the traditional custodians of the land and respect any of their elders who might be here today in particular. Can I also acknowledge the role of the College of Law in this exercise, in this series of lectures, and to thank in particular Amnesty International, Claire, that we've worked together over many years in a position which has been rather dismaying, and it's been wonderful for me to get to know Peter and to work with him on this lecture this evening. So what I would like to do tonight is to discuss what I believe is the regression in the protection of human rights in Australia, particularly over the last 2 decades. The ideological rejection of freedoms by some politicians and the media, and the unprecedented creeping expansion of executive powers and of ministerial discretions. I'd like to explore how the law and our courts have failed to check that abuse of power. In short, how did it come to this? And finally, to consider the merits of a federal Charter of Rights. I do appreciate, of course, that it's very appropriate that we should revisit the question of a Charter of Rights reported on in 2009, because this year is the 70th anniversary of the adoption of the UN General Assembly, by the General Assembly, of the Universal Declaration on Human Rights. And you'll all remember, I hope at least the older of you here, of course, that it was that extraordinary man, Doc H.V. Evatt, who played such an instrumental role in that Universal Declaration of Human Rights, and he was, of course, the President of the General Assembly when the Declaration was passed without a single negative vote. And I think his sheer personality and absolute determination that this Declaration should be part of the new world that we owe a great deal to him. It's also, of course, in the ACT, where under the leadership of the Chief Minister, John Stanhope at that time, a Human Rights Act was passed for the territory, coming into force 14 years ago. And Canberra has undeniably been a leader in understanding the importance of a Human Rights Act. Well, over the last 5 years, as former president, or as president then of the Australian Human Rights Commission, I watched as piece by piece legislation has been passed by compliant parliaments and oppositions that have expanded the power of the executive to detain without charge or trial. The detention of unauthorised maritime arrivals, asylum seekers and refugees for years on the doubtful ground of an administrative power to deport aliens is, of course, one of the best examples. But we're also now aware of holding terrorist suspects for extended periods of questioning well beyond the periods of most comparable legal jurisdictions, the stripping of dual nationality of citizenship, the retention of metadata laws that punish or diminish privacy and freedom of speech, mandatory sentencing laws that diminish the independence of the courts, preventive detention orders and control orders now in place, the rising imprisonment of indigenous youths and adults in unprecedented numbers, now among the highest in the world, the detention indefinitely of violent offenders after they've completed their sentences, and the detention of those whose visas have been cancelled on character grounds, with rising numbers of New Zealanders and Britons on Christmas Island. It's estimated, for example, that the non-reviewable and non-compellable discretion of Minister Dutton of the now Super Ministry of Home Affairs has 48 different kinds of discretion that, for practical purposes, are not reviewable by the courts. At the state level, we've also seen numerous new laws that diminish our freedoms. It's not only at the Commonwealth level. The Northern Territory's paperless arrest laws is, I think, one of the most egregious, which has added to the number of Indigenous Australians dying in custody. The Queensland bikie laws and mandatory sentences completely out of proportion to the alleged offences. The New South Wales laws against annoying behaviour during the Pope's visit that were mercifully declared invalid by the High Court, and attempts by both Victoria and Western Australia to hold juveniles in adult prisons. These laws breach common law rights to freedom of speech, movement and association, the right not to incriminate oneself, the principle of innocence until proven guilty, even in criminal trials. Only occasionally have our courts been able to intervene to constrain the overreach of Parliament. Well, I've come to believe that a bill or a charter of rights for Australia will better protect the rights of citizens, minorities and non-citizens, and to ensure a language and a culture of respect for the rights that underpin our democracy. The tragic stories of Marlon Noble, detained for 10 years without charge or trial on the basis that he was not fit to plead to criminal charges that were very quickly denied by the alleged victims and their mother. Ms. Dhu dying in a police custody in Port Hedland, arrested for parking fines and dying of injuries from her violent partner in another example of domestic violence. Or the Al-Kateb case that many of you will be aware of, a stateless person whom the High Court concluded could be held indefinitely in immigration detention. Or Dylan Voller, the Aboriginal young man restrained in a steel chair, hooded and isolated for 16 hours out of 24. These cases, I believe, could have been restrained or moderated if we had enacted a federal Charter of Rights. Well, you might say, when you look at some of these laws that I've been through, and one can go on about the detail, if each law is considered alone, you could say the rationale for it might be reasonable and proportionate, especially if the aim is to protect national security. Perhaps, it might be reasoned, the prosecutors and the government officials can be relied on to moderate any possible abuse of the laws. One might consider that the risk to liberty posed by a particular law is relatively slight, and it's not worth defending at the barricades. But when we look back over the last 2 decades, a pattern emerges. And this, I tend to focus on the years from 2001. The children overboard lie, later, captain of the Melbourne, and of course, attacks on 9/11. We've seen a conflation of terrorism with the Islamic faith, with those arriving in unauthorised ways by boat. But that pattern has now become one that is greater than the sum of its parts. As the Chief Justice of New South Wales, Tom Bathurst, put it, many small encroachments taken individually arguably have little effect. Taken cumulatively and over time and across state, territory and Commonwealth laws, they can be death by 1,000 cuts of significant aspects of our rights and laws that maintain our democracy. It's been said, and I think we have to keep on saying it, Australia is the only democratic country and the only common law nation in the world that's not adopted some form of bill or charter of rights, whether constitutionally entrenched or legislated. I believe that we've become increasingly isolated from the legal standards and jurisprudence of the countries with which we compare ourselves: Canada, United States, United Kingdom, France, Germany, and of course our cousin New Zealand. We've become isolated and we've failed to meet the international human rights standards, and criticised by over 44 nations in the Human Rights Council's Universal Periodic Review a couple of years ago. The comfortable belief that the rights of Australians are adequately protected by the Constitution, by anti-discrimination laws, by the common law and by a free press now deserves an urgent reassessment. The expansion of the power of government at the cost of our liberties is explained by many processes or factors. One is the failure of Parliament to protect our fundamental liberties. Accountability is declined in our post-truth era, where alternative facts and spin and personal ideology are preferred to evidence-based policy. And finally, and critically, our courts have not had the legal tools or, I believe, the will to insist upon the principles of legality as a check against legislation that violates our rights. For each of these reasons, we need to look again at Frank Brennan's report for a federal Charter of Rights to provide benchmarks for compliance with ancient common law freedoms and Australia's international human rights obligations. But this is all very abstract. What are the implications of this exceptionalist approach for Australian human rights in practice? And I think the illustration is best made by contrasting the decision of the Papua New Guinea Supreme Court in Nama and Pato in 2016 with the M68 case of the Australian High Court. You might recall that the Papua New Guinea Supreme Court was asked to consider whether the detention of asylum seekers on Manus Island, and there are still, I think, and it's hard to know the exact numbers, but about 650 or 700 men who've been there on average more than 4 years, coming up to 4.5. The court was asked to determine whether or not their detention was invalid under the Constitution of Papua New Guinea that provides no person shall be deprived of his personal liberty, subject to some express exceptions. It reflects in a way that provision buried in the middle of the Magna Carta, that no man may be detained arbitrarily without charge or trial by his peers. This is not an invention of a socialist General Assembly after the Second World War. This is a principle as ancient as the Magna Carta and older, that no person may be detained arbitrarily without charge or trial by their peers. Well, the Papua New Guinea Supreme Court concluded that indeed their constitution did prevent the detention of foreign nationals. It was unconstitutional and illegal, and it ordered the Australian and Papua New Guinea governments to end the detention of those asylum seekers, and we know then that the Prime Minister, Peter O'Neill, closed the detention centres in October last year. The detainees have been transferred to another Australian constructed accommodation on Manus Island, in effect replicating their continued detention. But 3 months before, in February 2016, in the M68 case, the High Court of Australia confirmed the constitutional validity of our offshore processing regime. And it's a rather damaging but distressing decision that I think most Australians would have no idea was one of our High Court. It concerned a Bangladeshi woman, an asylum seeker. She had come to Australia without a visa as a maritime arrival. She'd been held immediately on Nauru. She was pregnant, but she was mercifully brought to Australia for medical treatment to have her child. She then attempted to bring her through the proper processes to the High Court to challenge her return to Nauru. And she'd said that her forced return amounted to a penalty and could be imposed as a penalty only by a judicial body, and that the penalty, if to be imposed by the government, by the executive, would be a breach of the doctrine of the separation of powers. Well, as the case moved closer and closer to the High Court, it became clear to the public servants and to the legal advisers that in fact the Migration Act did not authorise officers to return her to Nauru. So what they did to repair the defect was to, the government, introduce an amendment to the Migration Act that covered exactly the period of the Bangladeshi asylum seekers' period of detention, and that would allow her and others in the future to be removed to Nauru. But what this did then was retrospectively amend the legislation in a way that made valid the attempt to remove her back to that country. Well, the majority of the judges rejected her challenge, saying that the government had repaired the defect with the retrospective legislation and that she was now to be returned to Nauru. Well, Justice Gordon was the only dissentient among the 7 judges, and she, in my respectful opinion, came to the correct legal opinion. She found the retrospective provision in the Migration Act was invalid because it gave the executive a power to impose a penalty, and penalties lie with the judiciary, not with the executive government. By contrast, and in a very useful judgment, Justice Gageler accepted the retrospective law and ensured the detention was within government authority. But he did so on the rather chilling basis that Parliament had been clear that it was authorised for the government officials to deport her back to Nauru. As the language was clear in the statute, Parliament had spoken, and therefore, because of the supremacy of Parliament, the legislation was now valid. Well, I find that decision extremely worrying because it in effect permits Parliament to pass laws giving very wide penalty powers to the executive and powers which were retrospective in their effect. I find it hard to imagine how the years spent in detention on Nauru do not constitute a penalty, and moreover, when it's retrospective, it breaches the criminal law principle that you cannot be guilty of an offence and thereby subject to a penalty if the act is not an offence at the time that you committed that act. The mantra is repeated by courts in case after case after case in Australia that executive power is to be interpreted by reference to the common law, but invariably the common law is ousted by the clear words of Parliament. So the common law has become an insubstantial spectre with little capacity to restrain parliamentary excesses. I believe that a Charter of Rights, even a simply legislated one, could moderate these now almost unrestricted executive powers granted by Parliament. The idea of executive discretion, or the overreach of executive power, doesn't excite much passion in the Australian community. I suspect most people don't understand that their elected representatives now have powers that are not subject to judicial supervision. The limits to executive discretion and the doctrine of separation of powers among government, Parliament and the judiciary seem entirely abstract, even arcane principles of constitutional law. But they're in fact enormously important to our democracy. And sadly, I think in Australia, we're poorly educated about our constitution, perhaps explaining but not excusing the failing of our elected representatives to understand the provision prohibiting dual citizenship. Well, will a Charter of Rights be a solution? It's true that for most Australians, most of the time, their human rights are respected. But a couple of years ago, the Australian Law Reform Commission was given a reference by the Attorney-General to identify federal laws that infringe our democratic rights. The Attorney-General notably and inexcusably excluded from that reference the common law prohibition on arbitrary detention, the very right that was most abused, whether it's by those with cognitive disabilities, violent offenders completing their offences, those detained on immigration grounds. That was excluded completely from the reference, but nonetheless, the Law Reform Commission found 121 examples of breaches of fundamental liberties, offences for advocating terrorism, prohibiting terrorist organisations, data retention laws, and the disclosure of special intelligence operations that attract a 10-year penalty, while ASIO officers, for example, retain total immunity from civil and criminal prosecutions. There are at least 52 examples of legislative reversals of the presumption of innocence. We're hardly aware of this. Mental intent or negligence have traditionally been critical elements of criminal responsibility, yet federal laws impose strict and absolute liability, not only in the relatively well-known areas of counter-terrorism and migration law, but also on corporations and for prudential environmental regulation, for commercial-scale copyright infringement, and others. We also now have laws that do away with the privilege against self-incrimination. Procedural fairness and rights to due process are threatened by various laws, including the mandatory cancellation of visas on character grounds. And there are bills now, just to bring this up to date, that Claire has mentioned, that add fuel to my concern and many others that the government is targeting advocacy within civil society. The National Security Legislation Amendment Espionage and Foreign Interference Bill has been introduced in response to what the Prime Minister refers to as disturbing reports about Chinese influence. Foreign political donations will be banned, and Australian and companies registered in Australia will be able to donate to political parties only if they are registered subject to laws that are much more stringent than apply in other countries. But you might say, well, this could be reasonably defended as necessary and proportionate to respond to a perceived risk. That is, until the practical effect of this bill is considered. Charities and research organisations say they're unable to continue their work when they have usually received some foreign funds. Media companies say the new espionage definition would see journalists given jail sentences for possessing sensitive information. Universities Australia is worried that laws could stop research collaboration with overseas institutions, especially as the Chinese government has partnered many in Australian research projects. Yet another disproportionate bill introduced dealing with foreign influence and the threat to advocacy in civil society is the Electoral Funding and Disclosure Reform Bill, and that it captures a broad range of donors who are no longer allowable donors and establishes a regime for registration with severe penalties, including 10 years imprisonment, to control a bill that establishes a system of reporting that's significantly more onerous than in the United Kingdom, Canada. What I believe is our isolation from the language of international human rights is the fact that the Constitution protects very few rights. We have a right to judicial review if there's been an error at law. We have freedom of religion, despite the misinformation that was circulated in relation to marriage equality. And we now await, of course, the Ruddock report, where they have cherry-picked a single right without considering that right to freedom of religion protected by Section 116 in the Constitution. They've cherry-picked it in a way that fails to understand that we have other rights that are not mentioned in the Constitution that might need to be protected as well. We have no rights common to modern constitutions, such as the right to freedom of speech. The High Court has had to imply a right of political communication, which is not quite the same thing. Our founding fathers did not mention the rights to privacy, freedom of movement and association. They certainly didn't prohibit arbitrary detention. Compared with more modern constitutions, our constitution does not prohibit torture or slavery or racial or sexual discrimination. The rights of children, the disabled and the aged are not mentioned. The constitutional protections that do exist do not apply to the states and territories, the right to freedom of religion being among them. But perhaps even more worrying is that the international human rights treaties to which Australia is a party, the International Covenant on Civil and Political Rights, Economic, Social and Cultural Rights, the Convention on the Rights of the Child, and most of the provisions of the Refugee Convention, among others, have never been implemented into domestic law. So the lawyers and the foreign affairs officials that followed Doc Evatt in the 40s, in the 50s, and the 60s, the 70s, 80s, right up to the Rome Statute, creating an international criminal court, we played a very strong and active role in creating that modern law, but much of it has never been given domestic implementation in our local Australian legislation. Curiously, as some of you may know, the Australian Human Rights Commission has a jurisdiction that includes the International Covenants on Civil and Political Rights and the Convention on the Rights of the Child. So when I go, and used to go, to see a minister or through our lawyers go to the courts and argue for the fundamental rights in those treaties, we will be met courteously, usually, with the answer, these are not part of Australian law. So that we were like ships passing in the night. It was very hard to make the point. Well, if we don't have constitutional protections, we don't have a Bill of Rights, and most of the treaties to which we're party are not part of Australian law, we do have other approaches. One is the common law, which can so easily be ousted by clear language of Parliament. But then we come to the parliamentary processes themselves. Let's keep an open mind. Perhaps the Parliamentary Scrutiny Committee for Human Rights can provide the check and the balance that other facets of our legal system do not provide. It's true that Australia has evolved an essentially parliamentary approach to the protection of liberty. As parliaments enact the laws, they should also be the guardians of the common law freedoms. But it became very clear to me at the Human Rights Commission that we are comfortable with an essentially parliamentary approach, but that our parliamentary representatives have not honoured that obligation. You might recall that the Labour Party initially supported a Bill of Rights, but ultimately, after the Frank Brennan report in 2009, decided that the better approach was to move within or establish checks and balances within the parliamentary system rather than legislation, and they established the Parliamentary Human Rights Scrutiny Act. And I, with great enthusiasm, wrote an article called Australia's Human Rights Cold. Well, I'm a great fan of the Le Carré's spy novels, and I thought this was a very clever title that reflect essentially political responses to the proposed law that I think any law school student would reports breaking down on part, but they are very rare. Even where a report has attention to possible human rights, it is ignored by governments. The committee could find a majority more than a statement of the opposition. The fact then brings me back again then to my concern now that we have a failure to provide legal tools available in most other comparable countries. Been constitutional recognition of our indigenous people quite at the political level. Even the more amendment will not be a panacea, but it would give sense of our law. Whenever I ran indigenous, legally known security prison in the North Territory, it was brought to the Human Rights Commission presidency. I, a man and others, and we had a case of 16 instances in which the steel restraint chair was used on this particular young man, and that he'd spent an average of 16 hours a day in isolation in a maximum security cell, and that he was usually shackled even when allowed to leave his cell. This was a contemporary tragedy from his birth, possibly with fetal alcohol syndrome, a disrupted and sad life, a brutal upbringing, and he is today in continued detention, having aged up into an adult facility. The Commission's report was tabled by the attorney with the words, "I table this report." It sunk without trace and was ignored by both federal and Northern Territory governments. But 2 years later, many of us watched the Four Corners documentary that included CCTV footage of the treatment of the juveniles at the Dondale Detention Centre, the use of tear gas, the language used by the guards, the stripping of these young men, and of course that iconic picture of a young Indigenous man in the steel restraint with the spit hood over his head. That generated an immediate response at the political level, and as we know, the Prime Minister established the Royal Commission, which is now reported. But my point is that, first of all, it's always the iconic image that moves the hearts and minds, that the reports just sink. We have so much evidence of breaches of human rights in Australia, so many reports, but they are largely ignored. But critically, had we a Charter of Rights at the federal level, it would have been possible for the complaint that came to the Commission to be dealt with through litigation in the courts, and that young man would have been given the kind of medical treatment he needed. And there are many other examples that I won't go through now, but just to mention very briefly, juveniles held in adult facilities is a phenomenon throughout Australia. We tried to do something about this in Western Australia and could not, where there is no Charter of Rights, but you will know that in Victoria, where there is a Charter of Rights, it was possible to challenge the detention of youths in an adult facility at Barwon, and the judge accepted that under the Victorian Charter, those youths could be or should be removed to juvenile facilities in Parkville. It's an interesting and important case to read, but is a very clear illustration of how a charter can help to achieve human rights within Australia, and those jurisdictions that do not have it aren't able to do so. Similarly, the Queensland's Vicious Lawless Association Disestablishment Act of 2013, which imposes a 25-year additional penalty on a defendant who has joined and is an associate of a declared criminal organisation. Had we had a federal Charter of Rights, those laws and the courts would be able to set reasonable limits and could not be overridden by exceptional circumstances. Well, it's been a long and winding road to get to this stage. We've seen the Frank Brennan report. It favoured a dialogue model which essentially gives the courts powers to declare that laws are inconsistent with or incompatible with the rights listed in the Charter, so that the matter would then go back to Parliament and retain the sovereignty of Parliament. There are many who argue that that would open the floodgates to litigation, but in fact that isn't what's happened in those jurisdictions that do have a charter. The ACT's Human Rights Act, for example, has an average of 8.1% of cases that have even mentioned the Act since its enactment 14 years ago. And in Victoria, only 1.6% of cases have ever mentioned the Charter of Human Rights and Responsibilities since it became law in 2006. Over the 10 years of the Human Rights Act in the United Kingdom, only 2% of cases have concerned a human right. So the real value of a Human Rights Act lies not in the litigation, which I've been discussing a bit tonight, but in their symbolic, educative, cultural and informative roles, restraining parliaments from passing laws that infringe those fundamental rights, and ensuring that government officials and administrators do not impose policies that do so. When protections for human rights get legislative expression, they form the scaffolding for a social culture that respects the rights of communities and the law. A legislative Charter of Rights can't be disregarded and will encourage compliance without resorting to litigation, as the Victorian experience shows. The United States in the Obergefell case that applied the equality before the law principle of the 14th Amendment. The court in that case was able to make a determination for the whole of the United States on the seminal same-sex marriage case. The dialogue model would be a much softer model. Many political leaders and scholars, and some in the media, argue against enacting a right on the basis that some of the nations that most egregiously breach fundamental freedoms also have entrenched bills of rights. And that's true, but the argument constructs a straw man. Charters of rights will not guarantee compliance with fundamental freedoms in the absence of representative democracy, a culture of respect for human rights, and an independent judiciary. Those that oppose Charters of Rights also claim that political issues are for Parliament and judicial issues are for the courts. Never the twain shall meet. This is not just a simplistic view, but it's a false argument. Politics, Parliament and the courts interact and overlap constantly. Legal and political questions are invariably intertwined. A political issue will typically be resolved by the passing of legislation that is then interpreted and applied by the courts. A policy is agreed at the political level, and Parliament passes legislation to give effect to that policy, and a new law is applied to the facts by a judge. Sometimes reform is achieved the other way around. Courts may provide the impetus of change by interpretation and revision of long-established practice. Examples will be known to you. Very importantly, the High Court's decision in Mabo No. 2, rejecting the idea of terra nullius. The High Court's decision in the Tasmanian Dams case, interpreting the external affairs power to support implementation of an environmental treaty. Or Tio's case, where the Mason Court created a legitimate expectation that government officials will take treaty obligations into account when making decisions. In short, then, courts haven't always refused to, been willing to acknowledge a change in social needs and culture and expectations. And they've done it in some of the most important cases that we have ever dealt with. Of course, there are also those who argue that a charter will enable activist judges to create the law according to their own lights and to their own political views. But have we forgotten who first articulated common law freedoms? It was the judges. From the 13th century, English judges have recognised the changes in norms, and they've crafted laws to reflect societal changes. Australian judges do not harbour unfulfilled desires to make the law. They're usually conservative in the best sense of the word, and they understand that their roles are limited to interpreting the law as Parliament has described it. Well, of course, timing is everything in politics. Australia has been elected to the Human Rights Council from 2018. Engagement with the Council may help persuade Australian politicians that it's important to meet our human rights obligations. Recommendations of the Human Rights Universal Periodic Review that I've mentioned have diminished Australia's credibility in chastising other nations about their human rights abuses. Some indication that our government respects the international monitoring process will be welcome. The recently elected Queensland government is currently drafting, I believe, a Charter of Rights. The road ahead may not be straight or smooth, but a Human Rights Act for Queensland has the potential, along with the charters of Victoria and the ACT, to build a national momentum from the states and territories up to create a federal charter for all of us. And I'm also encouraged by suggestions that the Labor Shadow Attorney General, Mark Dreyfus, is considering a charter if the party were to win the next election. So in summary, the Charter will allow Australia to meet our international obligations, to resume its leadership globally that we had from those days of Doc Evatt, and regionally as a good international citizen. Above all, I think, with a legislated Charter of Rights, Australia could return to the rule of law and to the principles of legality on which our democracy is based. Thank you all very much. Thank you. Thank you very much. Thank you. Thank you very much.
Thank you, Gillian. There are few in this country who speak with comparable authority on the protection of human rights. I suggest there are none who, in the exercise of their public office, have borne what you did bear in championing the rights of the defenceless. Please join me again in thanking Gillian. I now invite Professor Kim Rubenstein to respond to Gillian. It was Kim who Amnesty first approached seeking the collaboration of the College of Law in this speaker series, and we are indebted to you, Kim, for your support from the outset. Kim is Professor at the ANU College of Law, and in 2012 she was appointed an ANU Public Policy Fellow. Kim is a woman of many firsts. She was the inaugural convener of the ANU Gender Institute. She was named in the first citation of Westpac's 100 Women of Influence Awards. And in October 2013, she was awarded the inaugural Agna Ryan Award for leading feminist changes in the public sphere. And Kim will be known to many of us through her appearance on ABC TV's Q&A. Please welcome Kim.
Thank you very much, and thank you very much to Amnesty International and to the ANU College of Law Reform and Social Justice program, and I want to acknowledge its director, Associate Professor Matthew Zagor, who's sitting here in the front, who actually was the person who initiated this series and invited me this evening to have this opportunity to respond to Gillian Triggs' presentation. There is a personal delight in doing so. For those of you who are under 30 in this room, before you were born, I made my first appearance before Gillian as an undergraduate law student at the University of Melbourne, when Gillian was probably at the senior lecturer level, in my first mooting opportunity, and Gillian was the judge. I have since gone on to work with her since then, but I do have strong memories. My father was sitting in the room as a proud parent watching me argue before her, and she gave me very positive encouragement at the time. So I have you to thank Gillian for those early days of encouragement, and of course for continuing to be an inspiring role model for many law students around the country. I thought that I would also thank you, Gillian, in terms of the many law students in this room, some of whom I can see right now, who are studying administrative law with me at this very moment. And in fact, your comments tonight really powerfully emphasise some of the themes that we are discussing at the moment in relation to how our administrative law system really is the frame in Australia for the protection of rights, given we do not have a Bill of Rights. But it is within the context of administrative law that those very final words that Gillian pronounced as she concluded her presentation this evening really rings through in terms of the tensions that are underpinning our current democratic system. Because we have a commitment to the rule of law, which our administrative law system, both through the courts in developing the common law principles associated with administrative law, as well as through our statutes that have been introduced really from the 1970s with the Freedom of Information Act, the Ombudsman, the role of the tribunals in terms of merits review, and of course the Administrative Decision Judicial Review Act. All of those mechanisms were placed there to encourage transparency, to encourage openness, to encourage accountability, but fundamentally to reinforce a concept of a rule of law that applies to all in society. It applies to government as much as it applies to the individuals. But the tension that is underpinning our current system is when we say the law that applies to government, we're talking about that within a parliamentary structure where there is a belief that Parliament, as the representatives of the people, has a democratic responsibility and entitlement to legislate on our behalf because we've placed them there on our behalf to introduce legislation. And so when that majority acts in a way that may infringe and make vulnerable those who are in the majority, we see the tension at play as to when the courts can stand and effectively restrict Parliament in what it is doing. And without a Bill of Rights, there are limitations, which is exactly what tonight's presentation is about. And the two themes that I thought I would instigate our discussion for more open discussion, because I believe we have an opportunity for some questions before the end of the evening, is through the prism of citizenship. Now, many of you know that that is an area that I have been looking at and researching for many years, but there are two frames that I wanted to highlight that are relevant to the essence of what has been presented tonight. One is the formal notion of citizenship and the fact that the status of Australian citizenship is not a protected status in Australia, and so that things that we normally think of as citizenship rights are not in any way protected in our constitutional or legislative framework. So just as a show of hands, how many of you in this room are Australian citizens at the moment? So a majority of people in this room. And how many of you believe you have an inalienable right to live in your country of citizenship? About half of you. Well, the bottom line is that there is no right as such that we are clear about in terms of the protection of citizenship rights. And indeed, when David Hicks was in Guantanamo Bay and an attempt was made in the federal court to challenge the government in relation to its exercise of diplomatic protection, one of the arguments that was put by the then Solicitor General before the federal court, and of course the matter never proceeded because David Hicks pled guilty in order to release himself from Guantanamo Bay, but one of the arguments put by the Solicitor General was that the Australian government had an absolute right to prevent any Australian citizen from returning to Australian soil. And there is really no clarity in our understanding of what the current protections of citizens are. Indeed, so much so that, as many of you know, at the end of 2015, the current government introduced changes to the Australian Citizenship Act so that Australian citizens who are dual citizens are more vulnerable to their loss of citizenship than single citizens. So in this room, those of you who also, in addition to holding Australian citizenship, hold another citizenship, are actually vulnerable to having your Australian citizenship stripped from you, even though the person sitting next to you, who might do exactly the same thing as you, and is only an Australian citizen, can never have their Australian citizenship stripped. Now, in principle, the reason why that is the case is because Australia has committed to the principle that no person should be stateless, but the consequence is that we have now a society where dual citizens are much more vulnerable in their Australian citizenship than Australian citizens. And all of this is happening within a framework where we do not have clarity about what citizenship is, let alone the rights that flow from citizenship, which is part of the bigger package that Gillian presented tonight in terms of the lack of protection of rights within Australia. So that's one framework within which citizenship as a concept and as a legal frame fits with thinking through some of the issues that we've heard tonight. But the other area of citizenship that has become another particular interest of mine is that of active citizenship. So there's the formal legal status that we know whether we are or aren't citizens of a particular country. But the concept of citizenship is more than just legal status. It's also about participation. There are Republican notions of active citizenship that we as individuals living within a democratic society have certain rights and responsibilities in terms of not only our own personal rights, but also rights of others in the community. And being an active citizen is about being, in my view, someone who is prepared to contribute to public policy discussion, to contribute to the public sphere in relation to matters of intense significance for the society as a whole. And it's in this context that I believe that Gillian Triggs' work, both as the Human Rights Commissioner but in other aspects, is an example of active citizenship. She, in her roles that she has been able to take on over the years, has shone a light on many significant issues of public importance. But every single person in this room, whether they are a formal citizen or not, living here in Australia, has also the capacity to be active citizens. And I think it's in that context that the final point of where do we go next with questions about bills of rights speaks to all of us. We all have a voice, whether it be formally through a vote, which as citizens you are obliged to exercise in terms of voting at elections, but also in terms of our contribution to public discussion, the ways in which we talk to our fellow colleagues, whether at work or in childcare centres or on the playfields or in the libraries when we go to borrow books, wherever we operate as individuals, connecting with others within the community, we can be active citizens, influencing discussion about central issues such as whether we should introduce a Bill of Rights. And I guess it's at that point that I call upon you all as active citizens to perhaps thank Gillian again for her active citizenship and then start the discussion this evening. Thank you.
Thank you, Kim. We now open the floor to questions and ask that you keep questions very brief, very focused, so that we can accommodate as many as possible. We have been taking questions from the online audience all through the evening, and we have selected the best three, I believe, which we will now throw up on the screens. I've got a question from Hitachi. While we're waiting for the questions to come up on the screens, we might move to the audience. I'll go first to, we have tonight the honour of having students from Dickson College with us, and I believe we have a question from Dickson College. Sorry, can we have a mic, please, to hear? Thank you, Tom. Just while the mic is being delivered, sorry, it's been an error of mine. I should have mentioned that we're also honoured tonight to have Helen Watchers, the ACT, the President of the ACT Human Rights Commission with us. Helen's here in the front row. And the fact that the ACT was the first and one of only two jurisdictions in the country that's been mentioned tonight to have a Human Rights Act may be of relevance to some of the questions. So if anyone would like to direct a question to Helen, please do. And also if you'd like to direct a question to any of Kim or Claire as well as Gillian, please feel free to. So yes, we have a question here. Thank you.
So during your talk, you didn't really touch on what would be included in such a Bill of Rights. I was just wondering if that's a point of discussion in government, like what would be included and what does it mean if something isn't included? So, like, what does it?
Yes, thank you. That's a terrific question, because if you left something out, that would undeniably create a problem. Look, I think that I would suggest at least that we use the kind of model that's working in Victoria. But I'd like to see, for example, an anti-racial discrimination provision in there. I'd like to see something that recognised our indigenous peoples having a voice, advisory voice at least to Parliament. I think there are things that could be included. But basically it would be a fairly straightforward list of fundamental basic rights that we can all agree on. I think the marvel of having it as a legislated piece of law is that you could add to it where there was a sense that it wasn't covering the field properly, or you could amend it where the language wasn't sufficiently specific. So I'm not overly fussed about exactly what goes in. I think it's the point of principle that we've really got to deal with. But of course, if we did go through with it, there would be a major public debate, one would hope, about the content of that charter. But I think, frankly, keep it simple and keep it to those rights that we would see as absolutely fundamental, with a view to building on it later.
Thank you.
Thank you, Gillian. We do now have a question from online up on the overhead projectors. So, noting the polar opposite perspectives of the Australian public on a range of human rights matters, how would we determine what the Australian values are when drafting an Australian Bill of Rights?
Well, perhaps I could say first of all that I think one of the things we have to deal with is that we have such negative political leadership on this question. When Frank Brennan produced his report in 2009, there was overwhelming public support as he reported it, and I'm certain that was true. But also he had at least the support of the Labor Party at that time. So it was disappointing with all of that support that it wasn't ultimately promoted. But before I answer this question about Australian values, one of the things that I think has been so detrimental has been the willingness of senior politicians to denigrate the idea of a Charter of Rights. And to muddy the waters as to exactly what those rights do. And I mentioned post-truth. I think it's been particularly damaging in the context of marriage equality to argue that we do not protect religious freedom in Australia. That is, certainly we protect it by way of exceptions, but to argue that we've not protected religious freedom in this country is really, really quite wrong. So I think we've had very poor leadership, and we need more inspired leadership in the future if we're ever to get legislation to be introduced on these grounds. Now, how we deal with Australian values, if you were to keep the rights quite simple, the legislated right to freedom of religion, meaning certain things, you might articulate that in some ways. Right to freedom of association, the right to privacy. We could articulate all of these rights in fairly simple language. Then I think you wouldn't get a split on values. I think most Australians would agree we need a right to freedom of association, the right to freedom of speech, the right to freedom of religion, the right not to be detained arbitrarily. We could articulate these quite simply, and they would be rights that most Australians would agree at that level would be valid ones. But when they are put very simply, you run the risk, of course, that it gives the judges a greater scope for defining exactly what is within those rights. And that will be the criticism, of course, in that form of legislated Bill of Rights. But I think it's doable, and I don't think we would split down, we shouldn't split down on political grounds, because how do you disagree with a right to freedom of association? They are very broad-based rights. But inevitably these will be the kinds of arguments that will be made to resist legislation. But that's why I favour legislation, because it would be easily amended and added to in ways that would pick up what the Australian public comes to see as defects.
Sure.
Just to kind of follow on, every opinion poll that Australia's had about a Human Rights Act or a Charter of Rights, between 60 and 80% of the population say we want one. So I don't think the polarisation it is as likely as maybe the questioners asked. The other key thing that comes out, because Amnesty did some research on this, is also between 60 and 70% of the population actually think we've got one, and are then actually really shocked to find out that they don't. So I think, you know, it kind of links into, you know, what Kim was saying about active citizenship and active participation. Sometimes our leaders lead, sometimes they have to be led. And I think, you know, on this issue, you know, 60 to 80% of people believe we should have one. We need to start telling our politicians that.
Thank you, Claire. Might now take a question from the floor. Yes, over here, thank you. There's a mic coming.
Just continuing on from that point, you mentioned how some people think that we actually have a Bill of Rights. And on the point that, Gillian, you touched on earlier, in that a constraint on the use of government power is supposedly that expressing a clear intention to revoke a right would therefore get a democratic reaction from the people. Do you think that there has been a decline in popular engagement with human rights discourse, and what effect do you think that that has played on everything?
In terms of a decline in discourse, I think there has been a decline in that discourse. And one of the reasons for that is that we don't speak the language of human rights, because we don't refer to a charter. If you're in New Zealand or Canada or the United States, almost every issue of human activity is viewed through the prism of their Human Rights Act, whereas we've lost that capacity. I think there was a much greater discussion about this in the 70s and the 80s and the 90s, really, up until the late 90s. I think we were talking about the treaties we were becoming party to, the very important Convention on Disabilities that Australia had led the way on. We were talking about this. And of course the Rome Statute for the International Criminal Court and the idea of individual responsibility for criminal acts was part of the language. And Sir Ninian Stephen was the ambassador for that Rome Statute, and Australia ultimately, at the last minute, became an inaugural party to it. So I think we had that language, and we had politicians who spoke the language and who promoted it, including, of course, Gareth Evans, who'll be speaking in the next of these lectures. He was a major leader for the Charter, as was pointed out earlier. But I think since around 2000, we've seen a denigration of human rights and a refusal to use the language of human rights. And I found that some politicians would say to me when I was president, Gillian, yeah, we don't disagree with you on some of these issues, but don't keep mentioning human rights. Use some other language. Find some other way of describing it. Right to housing, or a right not to be homeless, or a right to proper income, or a right to a fair trial. But don't talk about human rights. It puts people off. So I had to contest with that one. But I think it's a problem, and we don't have that language now.
Thank you. Next question. Over here.
Professor Triggs, given that the High Court in Australia has been very clear...
I'm sorry, could you just speak a little louder, thanks?
Right into the mic. Sorry, can you hear me now?
Yeah.
Given that the High Court in Australia has been very clear that no court exercising federal jurisdiction may operate with a dialogue model because it fails to satisfy the requirement of a justiciable controversy, a matter in the constitutional sense, how would you get around that in terms of having a dialogue model at a federal level?
I don't know the answer to that question. I understand because I'm not a constitutional lawyer, and that is a definite defect on my part, but I think my understanding is that were the dialogue model to be adopted, it would ensure the sovereignty of Parliament and the Constitution in terms of the powers of Parliament, and it would allow a court to make the statement of compatibility. Do you see a problem with that?
Yes. I think the issue that Benjamin's raising is in relation to there needing to be a matter before the court for the court to be able to make a pronouncement. The dialogue model is not about seeking an advisory opinion in order for there to be a dialogue, but rather if a matter comes before the court and the court makes a pronouncement, then that pronouncement is in dialogue with Parliament in the process of the back and forth between Parliament and the courts in determining ultimately what will work within a democratic framework. But there still would need to be a matter before the court. And so in that sense, within a Bill of Rights framework, there would be someone who is affected by a piece of legislation who would seek to challenge it on the basis that it offends the new Bill of Rights framework. And then the courts would make a pronouncement, and from that pronouncement, Parliament would then have the ability to respond by changing the legislation. Whereas if you were in a constitutional framework, Parliament doesn't have an ability to respond because it's beyond its legislative power. So placing it within a legislative framework inherently makes it a dialogue model.
Okay, thank you.
Thank you.
But it could never be in the abstract. It would have to be an individual coming to the court to challenge it.
Another online question. How do we get priority in this area? Given parliamentary reluctance, do we need catastrophic events?
Well, that really is the point that I was making with the Dylan Voller case, that we only took attention or gave attention to the treatment of indigenous youths in detention when we saw the CCTV footage. We almost need the catastrophic event before we act. And that perhaps is the history of parliaments, the history of political action. But I think we need the civil society to be demanding change from our politicians. It's not coming at the political level. The political will is definitely not there. And I can see, the only way forward I can see is for advocacy. And that's really why I raised the point about the two pieces of bill, or two bills that are currently before Parliament. Because the attitude of the government over the last few years has been it's fine for advocacy groups to deal with the individual case, with the flesh and blood legal problem. But governments are offended, or this government in particular is offended by advocacy for the issue that has led to the problem in the first place. Now, of course we need advocacy, but there is now a very concerted attempt by government to create a chilling effect on that ability to speak out. But to come back to my point, I think the only way now, in the current political environment, and it can change, I think the only way forward is for civil society to speak up and to demand that politicians pick the issue up. It's happened, we've done it with marriage equality, where again, as Claire said, we have the public, the community, is out ahead of our politicians. And I think for that reason we need to be willing to speak up. I'm so pleased to see young people here tonight, but one of the things that's disturbed me a little is that young people are so put off by politics that they're not engaging in the advocacy. And I think it's important that they're educated, they're informed, they understand the issues. But I think to pick up Kim's point, it is a part of active citizenship to be out there advocating and speaking up on these issues.
We have how many more questions? One at the very back, thank you.
This is an interesting one to the panel. Does Elizabeth, Queen of Australia, help, hinder, or is irrelevant to an Australian Bill of Rights?
It's a marvellous question. I think she carries great soft power. I think it's quite possible that a humanist approach and a human rights approach could be one that our monarchy could support as constitutional monarchs, but in a soft power way. I don't think she's irrelevant to these questions, but as you know, she is very cautious about any public role. So I think I'll pass that one to Kim.
I think my answer would be that as a non-Australian citizen, but as the Queen of Australia, there is a certain disjuncture there in relation to rights of Australians. And I think until we have an Australian head of state, we won't fully embrace what it means to really protect citizenship in its fullest sense.
So you can probably tell from my accent that I'm not an Australian born, and I'm not a monarchist either. But what I would say is that we can learn from the UK in terms of their Human Rights Act. And that's about what it's actually done for people and how it's changed people's lives. So, you know, we've got some incredible examples of people who, without the Human Rights Act, would not have had justice and would not have had accountability. Some of you may have heard of the terrible tragedy at Hillsborough when 96 football fans were killed. If it hadn't been for the UK having a Human Rights Act, those families would never have got justice. There's a terrible case of a woman who was killed by her ex-partner. Her daughter used the Human Rights Act to ensure there was an inquiry into the police role in that terrible situation. So as a result of that inquiry, the daughter got justice, but also, and even more importantly, the police in Essex changed their practices to ensure that women going forward were protected. So what I would say, I can't comment on the Queen, but I can say that actually the UK's Human Rights Act has got some amazing examples how ordinary citizens have had their lives enhanced as a result. And I think that's something that we can and should learn from.
We've got time for one more question, and I know this will do a disservice because there are so many offering, and I'm going to do eeny, meeny, miny, mo. This way.
I wrote it down because it's a long one. With the Senate currently seeking input into the changes to the citizenship laws introduced by Senator Pauline Hanson, and the calls last year for the amendment of Section 18C of the Racial Discrimination Act, together with the many moves to limit rights in general, is the movement for an Australian Bill of Rights currently peddling upstream in a creek completely inundated by the voices and opinions of those who peddle politics of fear and division? Or is this prime opportunity as the only viable alternative?
Well, thank you for that question. And I think the 18C debate in particular was very troubling because it was attempting to strip out from the Racial Discrimination Act a provision which overwhelmingly, it seemed, multicultural Australia favoured that we retain in its form. Now, you'll know that 2 prime ministers and 1 attorney struggled over 3 years to amend that provision and ultimately failed in doing so. So I think that was a great comfort to me that we had civil society, the multicultural community, standing up for the importance of 18C in the Racial Discrimination Act, and it remains in place. I think even more troubling, for example, was the suspension of the entire Racial Discrimination Act for the purposes of the Northern Territory intervention. Now, it's been reinstated, but nonetheless, the discriminatory processes, in my view, continue 10 years after that Northern Territory intervention in ways that are disguised as special measures. But to answer your question, is this a sort of paddling upstream kind of argument? I think this is not this is an extremely difficult time in which to be arguing for a Charter of Rights. There's no doubt about that. But it is my observation after 5 years in the position. I feel very strongly that it's something Australians do favour, when they're presented with the arguments, and as Claire has said, the statistics, the surveys suggest that Australians still remain in favour of some form of Charter of Rights, then I think that we have a responsibility to promote the reasons for having one. So although we're in I think a very troubling time with misinformed debates about migration, with continued detention of asylum seekers, growing numbers of those losing their visas and citizenship on Christmas Island and in Australian detention centres, as well as the continued numbers on Manus and Nauru, threats to privacy, levels of scrutiny that we've never seen before, and laws on counter-terrorism that are disproportionate. I think these are troubling times, and it's important that educated, informed people, as you are, stand up for for the importance of a charter. So it's not convenient politically to put this argument. It will be rejected at the political level. Media will pick it up and they will be very negative about it. But I think that we have to stand firm and keep a focus on what is in the best interest of Australia and Australian citizenships, and to take us into the future, because we're coming from a very dark place. And I think we have the opportunity over these coming years to learn from these experiences and to know that we need the protections in our democracy, because otherwise we are losing the values that underpin that democracy. And that's why I think it's worth the battle up you know, I was going to say something colloquial, but I won't. We need to keep the battle upstream.
And just to add to that, I mean, I don't know of any right that has been was an easy win. So, you know, whether it's women's rights or disability rights, but the one thing you can guarantee is if we don't fight for them, it won't happen. If we'd been sitting here 2 years ago, nobody would have believed we would have marriage equality now. So change can happen, it does happen, and it happens because people like you in this room make it happen. That's why Amnesty is an amazing organisation, because it's full of people like you in this room. So, you know, if you're not a member, please come and join us. If you want to see a Bill of Rights, you know, come and join us. You know, there's some great learnings from ACT that you can help share in Queensland. We want to get Queensland over the line. Our activists in Tasmania are beavering away. Tasmania could be the next cab off the rank. New South Wales will be hard because Bob Carr doesn't want it and he's still very powerful there. But change never happens if you sit and say nothing. So come and join us, be part of the movement.
Thank you, and that brings our discussion this evening to a close. I again thank our speakers for bringing this discussion to us tonight, and I most especially wish to thank Gillian for travelling up from Melbourne and giving freely of her time to championing the cause of a Bill of Rights for Australia. I thank Matthew Zager and Nicole Harmon of the College of Law and the students of the Law Reform and Social Justice Project, our collaborators in this evening's event. And I thank my many colleagues from the ACT and Southern New South Wales branch of Amnesty, volunteers and staff who have worked tirelessly over many months to stage tonight. And it's always dangerous to name names, but I will name names. I particularly want to thank the remarkable Anne Robinson, who is not here tonight, but I think watching from her home in Braidwood, who made the promotion of this event possible with extraordinary skill and endeavour. And Josie King, who is sitting over there and has been patiently bringing the entire live stream process to work and managing Twitter and Facebook comments. Thank you, Josie. I also want to thank Kate Waterford and her colleagues on the branch committee, Ronnie Gorry and Inga Saris, who nursed this project through against all odds and brought it to the fruition it has arrived at tonight, and in Wagga a month ago. And I want to thank our office staff, Sian Williamson and Mark Alwist, for your stalwart support as well. Last but not least, my colleagues on the working group who are wearing bright yellow shirts, who have been slaving away on this project now for about 8 months. Thank you very, very much. I also want to make, these things don't happen easily and there are big expenses involved, and I really do want to mark the special, very generous consideration that's been given to us as a donor-funded charity by Damien Ma and his team. Damien is sitting over there, who is from Newcastle Studios, and Damien has managed the live streaming tonight. And I also want to acknowledge Natalie Dean, the business manager of the QT, who also has made the facility available here tonight at very concessional prices. Thank you both very, very much. Now, even with the kind assistance of the ANU, Amnesty has had to meet very, very significant expenses in staging tonight's talk and streaming it live to our online audience. So I do ask that you help us if you can meet our costs through donations as you leave this evening. There will be collection buckets at the door. Please also take a moment in the foyer to talk with the law reform and social justice students at their information desk, and take a moment too to sign a petition, learn about an action group, or register as an Amnesty supporter at the Amnesty information desks. Our letter writing group, led by one wonderful Rebecca Chen, is Rebecca there? Rebecca is waving from the back, is especially well represented in the foyer as you leave. You'll be lucky to get out with being accosted by them. Letter writing, that patient-tested tool of advocacy, is baked deep in the work of Amnesty, and please, if you can spare a moment, find out more about the work our group does. And finally, you've already found on your seats flyers. Bring it on is the banner. It says many things, and I think they have all been reinforced very purposefully by Claire. But look, if you have the means, can I encourage you to consider registering for regular financial support to Amnesty, whether it is in Yemen, Syria or Myanmar, on Manus or Nauru, or in the jails that house the unconscionable numbers of our indigenous people, especially our young indigenous people. Amnesty is there on the ground, bearing witness and advocating for the defence of human rights. Our investigations, our research, our advocacy cost money, and our only source is you. If this interests you, I know everyone can't do this, but if it does interest you and you have the capacity, please go to the contact details that are on the flyer to follow up with regular donation. Thank you for coming tonight. Travel safely home. Have a good night.